Okay, so the topic that our group chose is bioethical issues surrounding death. And the key points that we decided to focus on are the right to refuse treatment, withholding and withdrawing treatment, advanced directives, and palliative sedation, euthanasia, and physician assisted suicide. The first issue that we researched was the right to refuse treatment. And two key aspects of the right to refuse treatment are autonomy and informed consent. And a patient's right to refuse treatment is constitutionally protected. In 1891, the Supreme Court determined that no right is held more sacred or is more carefully guarded by common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestioning authority of the law. Which basically means that no one can touch you, not even a doctor, unless you want them to, unless you're like under arrest or in jail or something. And from this autonomy comes the concept of informed consent. A patient must be informed of the risks, the benefits, alternative treatments to any procedure in order to consent or refuse. And in addition to being informed, the patient also must be deemed competent in order to make the choice to accept or refuse treatment. The next issue that we looked into was the issue of withholding and withdrawing treatment. So, treatment can be withheld for religious reasons, a belief that the treatment is futile, quality of life issues, or financial reasons. The decision to withhold medical treatment is often difficult because it involves making decisions about whether or not to begin treatments for events that haven't taken place yet. For instance, someone doesn't really know how they'll feel about CPR until they need it, and at that point, it's too late to change your mind. The decision to withdraw a life-sustaining measure implies that a level of acceptance has already been reached, both by the clinicians involved and the family. And so by the time the team agrees on this decision, they've accepted that the patient is receiving no benefit from the treatments anymore. Interestingly, the consent process for withdrawing medical treatment is often less challenging than for withholding treatment in the first place. And that's probably because when you're withdrawing treatment, the patient's condition has deteriorated to the extent that, no further improvement is expected. So, advanced directives are the means by which all of these wishes and all of the things we've already talked about can be made known. And they assure that your wishes are carried out, but they also can alleviate strain, conflict, guilt that may be felt by the family. The Federal Patient Self-Determination Act of 1990 was passed with three goals: to reinforce and legally affirm autonomy of the individual as a patient and that patient's right to refuse treatment, to increase the use of advanced directives, and to decrease the cost of end-of-life care by eliminating unwanted treatment and allowing physicians to avoid defensive medicine. And a living will addresses treatment preferences related to nutrition and hydration, surgery and other procedures, respiratory support, and resuscitation, like CPR, meds, ventilators. The Five Wishes pamphlet is a legal document accepted in 42 states, including Pennsylvania, that identifies treatment preferences, durable power of attorney, spiritual requests, deathbed hygiene, and even funeral arrangements. So, when pain, weakness, functional impairment, hopelessness, indignity, intellectual deterioration, or loss of autonomy become unbearable, patients do have options outside of conventional medicine. Palliative sedation is the intentional administration of sedative drugs to reduce the consciousness of a terminal patient as much as necessary to adequately relieve symptoms. So basically, they're delivering a continuous supply of IV drugs to keep the patient sedated and not experiencing pain. The intent of palliative sedation is always to relieve symptoms, not to kill the patient. The patient ends up dying as a result of their illness, not the treatment. Palliative sedation is not part of the curing aspect of medicine, but it is part of the caring aspect. So, physician-assisted suicide and euthanasia obviously have a different end goal, but the same principles of caring and the alleviation of suffering apply. In the case of physician-assisted suicide, and as far as we could find, it does actually have to be a physician, not a PA or a nurse practitioner or anyone else who can prescribe drugs. It has to be a physician. They prescribe a lethal dose of medication to the patient, and then the patient administers the medication to themselves. So they're not killing anyone, they're helping the patient to kill themselves. Physician-assisted suicide is legal in Vermont, Oregon, and Washington, and conditionally in a couple of other states. Euthanasia, on the other hand, is the deliberate termination of life on the request of the patient by the physician. So the physician actually administers the drug and ends someone else's life. It's illegal in the United States, but it is legal in several countries, including Belgium, Luxembourg, the Netherlands, and sometimes in Colombia and Japan. So most people, unless they've had to deal with these matters with a loved one, haven't given much thought to the complexities surrounding death in the United States. And our research showed us that while these issues can be intimidating, they can also be empowering. It'll be our responsibility to understand the laws surrounding these subjects and be able to discuss them with patients and their families.